Do you want to save hundreds of thousands of dollars in estate taxes for your family farm? The Minnesota Family Farmland Deduction is a great tool that allows us to do that for our farm clients. Watch this video to learn what you need to do to qualify for this incredibly valuable deduction. I'm Jason Wagner, the farm lawyer. We help farmers, landowners, and rural families protect their legacies, secure their futures, and protect their farms. Minnesota's Family Farmland Deduction is a powerful tax break that is designed to help keep farmland in the hands of the family. This tax deduction has been around for a number of years. We use it all the time, but there's a lot of misconceptions out there about it. So if you own ag land or if you're a farmer, you need to know what this deduction is, how to qualify, and the huge impact it can make for estate taxes. Just a little background first. Minnesota has an estate tax. It's a $3 million exemption. So exemption means that's what everybody gets, whether you're a farmer or not a farmer. I have a $3 million exemption. You have a $3 million exemption. And that's what you get. When a person dies, we need to know what is the value of their estate. For farmland, that's typically going to mean what is the appraised value. And right now, we're still hearing land prices in southern Minnesota going for $13,000 plus an acre. So we don't just take what's on the tax statement or what we think it's worth, what we think it should be worth. We have to go with what it's appraised at on the date of death. So we stack that up along with everything else. And if what that person owns when they died is over $3 million in value, we potentially have an estate tax. But for farmers, the story doesn't end there. We can potentially now latch onto the Family Farmland Deduction. So this is a deduction that it's up to a $2 million deduction. And at a 13% estate tax rate, that deduction is worth up to $260,000 of estate tax savings. There are a few factors we have to look at on the Family Farmland Deduction. There are the before factors and the after factors. Before and after what? Well, before and after your death. The first one is you must own that land for at least 3 years before you die. So if it's a property that you bought, a year before death, sorry, that one's not qualified. We can't count it towards the deduction. The next one is the one where we do most of our planning around, and that is that the property must be classified as Ag Homestead in the year of death. So the only way that you're going to know that is you'll pull out your tax statement. Does it say Ag Homestead or Ag Non-Homestead? Some counties might put a special designation. If it's owned by an entity, it might say entity homestead or entity linked or something like that. So we need to know what is the homestead classification. We need the property tax statements, and it has to be shown there as Ag Homestead in the year of death. It must also be Class 2A land, which pretty much all farmland is going to qualify as Class 2A land. It just means black dirt, tillable land. So for the Ag Homestead classification, if you live on the farm and you farm on it and it's owned in your own name or in your trust, that's a pretty easy thing to qualify for. We don't really have to dig much further. But in some cases, maybe mom or dad has to move off the farm to go to assisted living or a nursing home. Did the Ag Homestead classification stay on? Well, you better double check because that deduction is so valuable. And the county should not be taking off Ag Homestead classification due to a move to assisted living or a nursing home. But they may not know that's why the person's not living there any longer. So we have to keep an eye on it. Another is maybe you did buy that farm. Maybe you did own it for 3 years. But for some reason or another, it never got linked up to your homestead. So you have to look at that. And sometimes I hear farmers say, well, yes, but I've exhausted my Ag Homestead benefit. And what they're meaning is that first-rate classification for Ag Homestead property starts to get exhausted. So they're no longer getting a year-to-year tax break on their property taxes, but that doesn't mean that we won't get a tax break on the estate tax side. So we want everything that could qualify for Ag Homestead to be qualified. So don't get lazy and say, yeah, I don't need that anymore because it doesn't matter anyways. It might not matter right now, but it could matter a lot at the time of your death. So let's make sure it's qualified. Another one we see, if we have land in 2 different counties, some clients think it doesn't count. Oh, I'm Ag Homesteaded in Winona County. I can't also be in Olmsted County. Absolutely untrue. We need to block that out, stamp it out, cross it out, throw it in the garbage, because that's not the way it is. You can still get your land that's in different counties linked to your home parcel as long as it's within 4 cities or townships. Remember, the homestead application comes from the Minnesota Department of Revenue, and it's administered at the county level. And then we get into much more complexity when we have land that's owned by an entity. And I'm not going to get into that today. It can be pretty complicated. You should definitely be working with an attorney before you put land into an entity, and make sure that you're thinking through the Ag Homestead implications of that. You also have to remember that if it's in an entity, you will need to have that entity comply with Minnesota's corporate farm law and file a corporate farm report every single year. Because that is another requirement in order for us to deduct the land after death is, has it been in compliance with or not subject to the corporate farm law? The next requirement is the after requirement. So mom and dad are gone. The land went to the kids. What are they required to do? Well, first, they have to be a qualified heir. It doesn't have to be just a kid. It could be, well, of course, your children or grandchildren. It could also be one of their spouses. It could be your spouse, or it could be your parent or grandparent. So if we have the land transferred to a qualified heir, so if it's in the hands of this person and we've met all the before requirements, now we're starting to check the box on the after requirements. Next, the qualified heirs must keep that land as Class 2A property. So again, as long as they keep it as farmland, and they must not sell it to anyone other than a qualified heir for at least 3 years after your death. So let's break that down. Has to stay Class 2A land. Does that mean it has to stay Ag Homestead? No, it does not. That's a big misconception that we deal with frequently, is people think that it has to maintain Ag Homestead after death. That was in an early version of the law that's been amended several years ago. It's no longer a requirement. It just has to stay Class 2A land. It can convert to non-homestead after death. It's not a problem. Next is that 3-year holding. Well, maybe the land went to a non-farming heir and they want to sell it to a farming heir. Is that going to blow the deduction? No, you can do that. As long as they would both qualify as qualified heirs, they can sell it between themselves in that 3-year period. They just can't sell it to somebody else. Or else then they would be subject to a recapture tax, which is 16% versus the standard estate tax rate of that first rate bracket of 13%. Finally, we do have to file an information return after death. We have to do it at the 2nd anniversary of death and the 3rd anniversary of death. So we're not out of the woods, so to speak, on estate administration within that first year. This is going to keep going for that 3-year period after death, where we have to continue the estate administration for at least those 3 years in order for us to stay current on the deduction. But by utilizing this deduction, we can deduct up to $2 million of farmland from the estate, plus we get our $3 million. So now, farmers, you get a $5 million deduction in effect by making sure that you're qualifying for this. And if you're married and have a good estate planning attorney and a sound estate plan, you could double this deduction so that you and your spouse are both using this $2 million deduction. So now we're protecting up to $4 million of farmland plus our $3 million per person. So that's up to $10 million of estate tax protection in Minnesota by having a very good estate plan and an estate planning attorney that understands this very incredible deduction. So if you'd like to hear more, follow me. I'm the Farm Lawyer, and check out farmlawyer.com.